Now is the time set for oral argument in cause number 1CA-JV190081, Alexandra K. Appellant versus Department of Child Safety, Navajo Nation IG. For everybody's information, we are recording these proceedings today, both audio and video recorded and live streamed. So barring unforeseen problems, you can critique your work in a couple of weeks. Counsel, each side will be entitled to 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all of your time. Ultimately, reserving that time is your responsibility and will be left up to you. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and the issues attendant to this argument. You might want to keep that in mind as to how you use your time as you proceed this morning. Counsel, when you come to the podium, each of you, I would ask that you state your name and who you represent. And with that, sir, you can begin. I assume, sir, you can begin.
Thank you. Yes, good morning. I'd like to reserve 5 minutes for rebuttal, please, for the appellant. My name is Philip J. McCarthy, Jr. I go by J. And I represent Alexandra K., who, may I call you Alex? That's how I refer to her. We are now here for the third time in this case. I know Judge Johnson was on the panel for the first appeal, which was handed down in 2017, and it was a situation where Judge O'Connor at the trial court level had not applied the Indian Child Welfare Act. She took the position that because the parents' rights were terminated, even though the child was an Indian child, it was reversed. The second appeal, Judge Morris was on the panel, and at that time, it was discovered there's an intergovernmental agreement from 2014 that under the federal law, 25 United States Code 1919, makes it a binding agreement. And it was a resolution passed by the entire Navajo Nation Tribal Council, and we had never been disclosed. And under that, Alex was the preferred placement, which is a critical issue because all through the litigation since 2016, in May of 2016, when the juvenile court said this child is a Native American Indian child as used in ICWA, the burden of proof has been placed on my client, and it should have never been placed upon her. So here we are today. The burden of proof in the last hearing was upon the state to prove that the current placement met the good cause provisions. Now what's critical today is I do not believe you have much law in Arizona on this, but in December of 2016, for the first time, the federal government issued binding federal regulations on the Indian Child Welfare Act. And the critical one that you need to consider, I'm sure you have, is 25 CFR 23.132. And that says the court should, not shall, but should utilize the specific grounds listed. Now, one of the other things that you need to look at is 25 CFR 23.132E. And E is critical because it basically says that if the placement of the child was in violation of the Indian Child Welfare Act, you cannot consider ordinary bonding and attachment as the basis to deviate from the placement preferences.
Doesn't it say based solely on that?
Yes, based solely. That's
so it
correct,
doesn't
Your
say
Honor.
you can't consider it, but
No.
it says it can't be the only consideration.
But I believe if you look to what we will go through, I'm sure you will, what the trial court or juvenile court said were extraordinary circumstances. The real issue there that they're relying upon is bonding. And think about this. We brought this to the court's attention in 2017, and they never, ever went into court under the foster care provisions. So the Indian Child Welfare Act, 25 U.S.C. 1915A is adoption placement preferences, and B are for foster care. So this placement, which is not a preferred placement, never went into court and said we need to now have a finding. And if you need the case law, I think it's the Jared case, it's in our brief.
But wasn't that the issue on the most recent remand?
Well, we brought it up in 2017. It was never, the court rejected that argument. We did a motion in limine on that issue and it was denied, so it's part of the appeal, Your Honor, if that answers your question.
I guess I'm misunderstanding. I understood you to say that the trial court has never considered the applicability of the Reg 123E saying, 132E,
Yes.
saying that placement to a non-preferred placement should not be based solely on
Correct.
non-equal bonding. I
We-
thought that was the issue.
It is an issue here because we filed a motion in limine to try to have the court understand that limitation and our motion was denied.
You don't think that, what motion was that?
Well, we had a motion in limine before trial saying, look, you cannot consider ordinary bonding and attachment, as Judge Morris said, as the sole basis for good cause to
No,
deviate.
I thought the motion said you can't consider the bonding at all.
Well, we have asserted that bonding before or after the May date,
May of 2016.
correct,
That's, yeah, that,
should not have been considered if that's going to be your principal way of getting to good cause under Section A. And if you, I'm going to jump to what the court did. So what is undisputed in this case, there are a few things I think are no issue about this, is that in May of 2016, this became an Indian Child Welfare Act case. We've discussed the two appeals, and then the third trial, Alex, can't say names, the burden of proof was shifted. The court, first of all, the state never went into court and alleged any of the basis under the reg. It's undisputed. They have said, we don't need to, we can go to the guidelines. The guidelines are not law, they're not binding, and we think just to jump to there like that is contrary to what the intent of the law is.
Help me with your argument a little on that, because I think what you argue is that because the regulations say should,
Yes.
that means shouldn't consider anything else. And that seems to be a kind of a stretch,
Well,
an interpretive stretch that I'm not sure how we're going to get to.
Well, I think the point is to just out of the box say, we're not even going to try to prove any of those. We agree on that. They never have said a single one of the grounds.
Right.
To say now we have extraordinary circumstances. And the first one, I'll just go through them. They're listed here. The first one is the child has been in foster care since October 29, 2013. That cannot be a basis for this finding because what you are saying is failure to comply with the law, which has repeatedly occurred in this case. You can utilize that, drag something out, and make it now extraordinary. That's contrary. If you find that these are a basis and you can avoid complying with the statutory and regulations, you are setting a dangerous precedent. Now,
What part of it can't they consider? Because it seems like you could consider at least from 2013 through May 2016.
And
The
that's
bonding that occurred
you
at that point.
can, but there was never any testimony that distinguished that, Your Honor.
Well, but the court was relying on, as I understand the record, on testimony it heard way back then.
Well, exactly, but remember, the child had only been in the current placement 4 months. 4 months before it became an ICWA case.
But this is an unusual case where
But,
the
Your
foster
Honor, if-
parents
Hold on,
were
counsel.
in and around the child. all
In
that
and
time.
around is not the same as being in a parental role. The other thing that was totally disregarded, I believe, was the request of the parents before their rights were even terminated, and we've briefed that. It's in there. They made it clear they wanted the children together with Alex. So back in 2015, that was clear. Now these children, I mean, this is just not about IG. This is also, she has an older sister, and these children don't know each other. Now,
Well, those two do know each other, actually.
Well,
They
if
talk,
you-
they
I would ask
not
you-
most recently, but they're, of according to the record, they did talk.
Well, I would ask you in the brief to look at the social worker from DCS who was the social worker for the older girl, AV.
And I've read that testimony.
She refutes this idea that this foster home was promoting a relationship between those two girls.
She refutes the idea that foster parents were willing to bring the older daughter in. She doesn't refute the notion that they talked regularly, they visited.
They did not talk
before
regularly.
things, there's evidence before the court that they did, before things fell apart with the older sister.
If I may, Your Honor, there's also evidence that during the time that you're talking about, my client and her son had regular contact and went to the treatment centers. So I understand there's findings, but findings have to be based, I believe, on substantial evidence. You can't make a finding when the record doesn't present that.
You know, let me say, and I see several people here, nothing in this record shows that your client would be anything other than a fine parent for this girl. So we are not disrespecting her or that relationship.
And I understand that, Your Honor. I did not interpret any comments. But I want to make sure you understand that so the first one, the length of time in foster care, when we've had 2 appeals and they've been reversed, how can you use that against saying, well, that's a basis now to avoid the regulations? Now, let's talk about the relationship that Alex and her son have with the little girl. Now, remember, these children are 20 months apart, approximately. And right now, they're still little kids. These are little kids still. I mean, Javi, Alex's son, was born in 2014, and IG was born in 2012, the latter part, I think in November, the end of November. So I would ask you to please review Exhibit 22. Exhibit 22 was in 2016 when Alex and Javi were allowed visits. They had 3 visits. Please review that. You will see that the visits did not go badly. They went very well. And you will see that the individual supervising it expressed over and over her concerns about the foster parents. Then they say, oh, the little girl's having nightmares. No more visits. So did they do anything to try to start them up again? Did they try to do counseling? Nothing. Nothing. So Alex, on her own, goes to court to get an order so just the children, little children, can have visits. And that was in May of 2017. She had to go in and get that order. How many visits have there been? 1. 1 visit between little kids, and by all accounts, it went well. And the evidence is overwhelming that they said there would be monthly visits. Monthly. I mean, you can look at this file and go, what is this? This is not the way you conduct a case. So these children, to make a finding, they have no relationship? When it's because DCS never facilitated the order, and then we file a motion, again, in limine to say, Judge, you can't make this. How can someone not comply with a court order and then you use that to make this finding? She denies it. We file so in October of 2017, before the second appeal, we filed a motion to compel the visits. The judge denied, because she denied the motion for good cause to deviate. So she said, nope, no visits. We didn't even have a hearing. So then we come up, you know the story, we win, we go back, we file another motion for contempt. And I would ask you to read what Judge O'Connor says on the record. Because the position taken by the department is we're not in contempt, we only had to do 1 visit. Yet we had information showing Alex was trying again and again. In fact, there's even information on the record where I had tried to facilitate it and never even got a response. Not even an email back. It's all in the record. If you need the sites, I'll give it to you. But what we hear from Judge O'Connor is, this is on, I believe, So I'm going to reference you to the January 8th, 2019 hearing, page 72 and 73. And at that hearing on,
What
this
was
is
the
on the.
date? I'm sorry.
Oh,
Again?
I'm sorry.
What was the date again?
January 8th, 2019 hearing. And this was on the motions for contempt and also in limine to try to prevent this before. And here's, at that hearing, the department takes the position, we had one visit, that's all we needed to do. You didn't order any more. And she states, if you read page 72, line 21 through 25, and page 73, 3 through 12, she clearly states, no, this was a order for visitation, plural. This was not an order for one visit. Yet she again denies any relief. So this is a bunch of malarkey, these findings. To say this is extraordinary circumstances should not be circumstances that arise due to failure to comply with the law or court orders. That is what has happened. If you say sanction this, you give a green light for this conduct to continue. Now let's talk about sanctions. I don't have much time left. Judge Morris knows from the second appeal, we got up here, in the middle of it, we found out there was a intergovernmental agreement that has the force of law. It has never been disclosed. Never. And it's in the record, the department's position is that we have no obligation. No obligation. Now, what is amazing is it is because of that, from the day one in May of 2017, my client should have been the preferred placement. We have 3 years of litigation that should not have occurred had this been disclosed. Now, in the answering brief, they say, well, we have no obligation to give it to counsel. But they had an obligation, I believe, ethically, to give it to the court. I believe the ethical rules governing attorneys say you have to provide the court even case law or other material that controls the case that is contrary even to your client's position. That has never been done.
Well, that's certainly true under Rule 11, but didn't the judge conclude that for whatever reason, and unfortunately, no one knew for a while about the existence of the IGA?
Well, okay, Judge, I'm sorry. I don't buy that. The IGA was negotiated by the Attorney General and DCS. They knew it existed.
Well,
And there's 21 other tribes, so if you sanction this conduct, how many other of those IGAs, which now their position is, oh, we had to ask for it, and it would have been given. Well, it's undisputed. If you want the site, it is, hearing was 129-19, page 23, line 11 through 21, and on the 29th of January, page 22 as well. So January 29, page 22 and 23. And it's clear that it was not available. We couldn't even find it. And this came out in the hearing, if you need the site. There's one from 1997 that is null and void.
well, I mean, my view is that the disclosure of it, handing it over, is a separate matter. The error was in not acknowledging that the IGA controlled and actually provided that your client would be a preferred placement. But what I understand the trial judge found is that the lawyers doing this for DCS didn't know about the IGA.
Judge, that's
You're-
not their
you're ma- you're
that's not their
making-
position, though.
You're making,
Their position, that is
I-
not their position.
where can I see in the record that the DCS lawyers acknowledged that they knew of the IGA but failed to disclose it?
Well, you're asking the impossible. I couldn't even find it. I can't put them on the stand. The IGA was known within the department. It was known within the AG's office. Your Honor, it's a double standard. If this was a private attorney saying, oh, I forgot I had a contract, we have obligations. This is a serious.
Didn't you know about the IGA long before?
Judge, I knew about it. I could give you the site.
I believe it was in August of 2017.
Well, no, I knew about a 1997 IGA, and it's in the record now because you quizzed me on that and challenged me. And if you want the site, I will give it to you. It's page, January 29, 2019 hearing, page 6 and 7. And Judge O'Connor is asking me, and I'm saying, Judge, I have the 1997 one. I can't find any other one. Everybody says it's null and void.
What is null and void?
There was an intergovernmental agreement, we call it an IGA, Your Honor, and it was between the Navajo Nation and the
Gotcha.
state.
The earlier one or the later one?
The earlier one I knew about in 1997. That one, everyone I talked to said it's no longer valid.
It is null and void, is my
It's
point.
null and void. And so when we had a trial, I had asked, my question was, is there an IGA? The social worker for the Navajo Nation who testified, but they are not a party, said, yes, there is, and they're not following it. And I'm not getting records, as I believe the rest of her answer. I had no idea what she was talking about.
So you were asking her about an old one.
Yes, and the
Well,
old,
you were asking, is there a current one?
my question, to be clear, was, is there an IG, an intergovernmental agreement? So the point is, the 1997 one and the 2014 one are absolutely different. They don't, in this topic before you. So the department's position.
And after that answer from the social worker, which seemed to indicate that there was one, did you file a request at that point for one?
I called everybody I could, and everybody told me they had no idea what I was talking about.
Did you make a formal document request to DCS at that point?
No, I called the Attorney General's office. I mean, I should probably be sworn, because this is not in the record. But I mean, the point is, why am I the one that is running around doing this? This is not the way the law is supposed to be set up. I mean,
You're the one that's
Judge,
interested in obtaining it, is what?
well, but Judge, it controls the law of the case. Don't you think DCS should be saying to the court, here, you need to know about this? I mean, why am I the one saying you should have done this? I find that, I have a hard time, Your Honor, because I did try to find it. You know, I cite Judge Slackett rather than my Irish temper for what he said about disclosure. I put it in both briefs. It's pretty clear what he thought about why you had to have mandatory disclosure. And this case is, if you only had asked for it. If I'd only asked for it. I didn't know it existed. In fact, when we were here for the second appeal, remember the court was saying, well, we couldn't find it. The court was trying to find it. And in the record, they admitted that it's only available internally to the AG and DCS. So if you need that site, I have that as well. Now, I'm out of time, so I apologize. I was going to tell you the standard of review is very critical, and I'll try to get that when I come up again, because
I think you're out of
I
time.
think you're out of time, counsel. Thank you.
Yeah, please the court. My name is Dawn Williams from the Attorney General's Office. I represent the Department of Child Safety. And as our briefing made clear, we take exception with a lot of the factual assertions made by the intervener in this case. The juvenile court did not rely solely on bonding and attachment in making the decisions here. It was one consideration that the court had among many.
What else did the court rely on?
The court relied on, for one thing, the regulation says the court may not rely solely on ordinary bonding and attachment. And the court relied on evidence that had been presented earlier about the significant damage that would be done to this child if she was moved from this placement.
Isn't that the other side of the coin of ordinary bonding?
It is a little bit. So, but then the court also relied on the fact that the Navajo Nation social workers stated reason that their preference was for intervener as placement was that she would facilitate the children's ongoing contact with their Navajo relatives and the Navajo community, whereas there was evidence presented by DCS that DCS had also made such efforts and that the foster parents were willing to do so as well.
And when did that seem to turn the tide? What caused that to turn? I mean, that suddenly all of that seemed to get disregarded?
I'm sorry, all of what was disregarded?
I agree with you. The record appears pretty clear that the position of people that I thought would have been listened to was kind of ignored in favor of the parents, I'm sorry, I'm losing.
foster parents?
Foster parents. What was the tide turner there?
In terms
Why
of,
wouldn't the people who typically are asked to respond to those questions and responded differently, when did it become the foster parents that seemed to turn the tide? What was it?
well, the issue was that when this went back on remand, because such a big deal had been made about the fact that the intervener was the one that had asserted she was the only one willing to maintain those connections, that then it became apparent that the foster parents needed to provide evidence regarding the efforts that they had made to instill those types of relationships in their efforts to try to locate family members and that sort of thing. So it was part of the evidence that was presented on remand.
You would agree that the evidence presented to the trial court, if we were reviewing de novo, would seem to strongly support that the intervener is much more committed to maintaining the family relationships and supporting the child's exposure to her cultural roots.
I would disagree, Your Honor. The intervener knew that this child existed and adopted her newborn brother, but made no efforts to have any contact or any relationship with this child for the first 3 years of the dependency, made no efforts to have her adopted child, have a relationship with the older half-sibling for any of that time. It was not until the day of the termination hearing, when the parents asked that she be the placement for this child, that she became involved and asserted an interest in preserving those family relationships. So arguably her assertion now that she's interested in maintaining those relationships is belied by her actions for the first 3 years that this child was in out-of-home care. And again, as the court said, the department has no reason to believe that she would be anything but a wonderful parent to this child. But the fact of the matter is, this child has been in out-of-home care since 5 years now, and so since 2013. So the juvenile court cannot simply disregard that passage of time. It exists. The child has grown up in a home with these parents. And contrary to intervener's assertion, she had not only been in their placement for 4 months at the time of the severance action, she had been transitioning into that placement for approximately 7 months prior to that. So she had been spending a significant amount of time for nearly a year prior to the formal placement, where she was no longer spending any time with the parents of the current foster parents. So the fact that she had established a relationship with her foster parents prior to this case ever becoming subject to the Indian Child Welfare Act is something that the court could and should consider and did consider. And so the fact that she had established those bonds during her most formative years was something significant for the court to consider. The court, as we were discussing, had several other considerations regarding what the court labeled extraordinary circumstances. Arguably, there isn't an extraordinary circumstances mentioned really anywhere in the rule or in ICWA itself, but I think the court was trying to find a way to say, here's what the big picture says. And the court acknowledged that it had to consider that the child's best interests were presumably served by placement within the placement preferences. The court knew of that and considered that, and knew once we were back on remand that that meant that placement with intervener was presumed to be in the child's best interest. What the court found essentially was that the department had rebutted that presumption, and that the evidence regarding the child's needs, her special needs, her relationship with her sibling with whom she had an established relationship was more important.
You said special needs, which usually signifies something to me. I want to make sure I'm following you. What do you mean by that?
Correct. I just mean that the evidence had been that if this child were to be transitioned into a new home, it would take a significant amount of time to do that, to ensure
But this
that
wasn't a special needs type
No,
placement.
it wasn't in terms, she didn't have any special medical needs or emotional needs, just the needs that would be attendant to moving a child from a bonded placement to a stranger. And so those were the issues that the court was considering. And even intervener's witness testified that it would just be a matter of minimizing damage, not eliminating it, and that a transition would take at least another 4 months. And so what we're talking about is maintaining this child in foster care for another extended period of time, when what the court found was that really wasn't necessary. The child's needs as an Indian child could be met in her current placement. And that's what the court was required to consider.
Have you found any other cases like this where the court is presented with pre-ICWA bonding versus post-ICWA bonding, if you will? That's what makes this case difficult, isn't it?
To some extent, it is. And I have, I didn't do a nationwide search. I'm not aware of any Arizona cases that present this particular unique scenario. And it is unique. And that's why in the very first appeal, the department conceded, yes, ICWA applies to this case. It may not have looked like it initially, but it does, because even though mother's rights had been terminated, she became a member of the nation, and that made the child eligible, and that made the case subject to ICWA.
I'm sorry, that made it?
That made the case subject to ICWA. So once that happened in May of 2016, the department acknowledged ICWA applied from that point forward. Counsel has argued that the department never made or requested a finding of good cause to deviate from the placement preferences for a foster care placement, but that was never required. The definition of a foster care placement is a temporary placement. We have always been, because ICWA didn't apply until after the parents' rights were terminated, we've always been discussing an adoptive placement preference, because what we're deciding is where this child is going to be raised permanently. So it was never necessary for the department to ask for good cause to deviate for a foster care placement.
So tell us about the IGA debacle.
Your Honor, as we conceded at the last oral argument, this was not a deliberate attempt to obfuscate anything. It was simply that no one realized that this IGA established a different order of placement preferences for adoptive placements. And as I acknowledged to the court, I'm more familiar with this IGA than anyone else in the AG's office, and it never occurred to me that this IGA established a different order of placement preferences.
So DCS lawyers, including yourself, who do this work, knew of the existence of the IGA, yes, but hadn't read it hard.
Correctly, hadn't recognized the significance of adding a number 4 in, section 9A of the IGA. We simply did not recognize that created an entirely different order of preference.
What was the section named? What was the title of it?
It was adoptive placement preferences. But the issue was partly that the Indian Child Welfare Act says that the tribe can establish a different order of preferences. In this case, the tribe has established an entire different category of preferences. The department doesn't dispute, however, that it entered into this agreement with the nation and that it is a binding regulation or a binding agreement between DCS and the nation at this point. I would point out that the intervener claims that this will open the door for DCS to ignore intergovernmental agreements with all of Arizona's tribes, but Arizona only has an intergovernmental agreement with the Navajo Nation, at least in terms of ICWA placements. So that's the only existing IGA right now, although there are others that are being discussed, but nothing is even close to being negotiated or finalized.
Let me back up just so I understand. So your argument, because I will tell you there's some saliency to defense counsel's argument that you, as the representative of DCS, and as you just told us, probably the best expert in the office on what this agreement says, how can we affirm a trial court that said, well, she just didn't know? So I want to make sure I understand. Your argument or your position is that the ICWA provision, which allows the tribe to change the order of preferences, it had never occurred to you that when they restated the same order as set in the statute, but then added a 4th category, that changed the order of preference?
Somewhat. Part of the confusion lies in the fact that
because the IGA, the agreement lists the same order as the statute for 1 through 3, I believe.
Correct.
Right?
Yes. And part of the confusion is that the foster care placement preferences includes a preference for placement approved by the tribe. And so, and the adoptive placement preferences do not. So when that was added, it was I can't say, I don't recall at the time we were negotiating this, but I assume I just looked it over and thought, okay, approved by the tribe, because I was used to seeing that in the foster care placement preferences. And it didn't occur to me personally that that added a new category of placements for adoptive placement preferences that hadn't existed before. And so in my training of the Assistant Attorneys General in our office when this IGA was enacted, I don't recall ever pointing that out to anyone. I don't think, because it hadn't occurred to me as anything significant. So certainly the Assistant Attorney General who was responsible for the placement hearing wasn't aware of it.
Is adding, and I guess this is beyond our scope here, but is adding a fourth category consistent with the statutory authority to change the order?
That's something that we haven't raised, but it is a question that we've had. Again, we're acknowledging that it is in existence and it is there.
You're not contesting the validity or
Not at this
force of
time,
it?
no.
Then I'll quit thinking about that.
I will too. But I would point out again that this is analogous to an attorney overlooking a case that is controlling on point. It happens. Sometimes attorneys are not aware of a case that may say that the court should do something other than what the attorney has argued. And what the court found here is that this wasn't a deliberate attempt on the part of DCS or the Assistant Attorney General. This was simply an oversight. And so we came to court and discussed this last time and went back and presented it to the juvenile court and acknowledged, according to this agreement that we have with the Navajo Nation, the intervener is the preferred placement. We have never disputed that since we discovered the existence of that number 4 in the IGA.
And that's gotten no traction.
I'm sorry?
That issue, the provision number 4, the change that should have been recognized and wasn't. The fact that it exists has gotten no traction in this case.
Well, the court acknowledged it right up front and said,
And changed what?
well, ultimately it didn't change the outcome, but the court said, I recognize that this is the presumed best interest of the child, and here's why I'm finding that there is still good cause to deviate from that preference. So I think the court acknowledged that she understood that this was a preference. It was a presumption that had to be acknowledged and had to be given weight. I don't think that intervener has demonstrated that the court didn't give it the weight that it was due. And
you think the court did give it the weight that it was due?
yes,
Knowing that the IGA was there, knowing that the IGA had changed the wishes of the nation. It just went the way it did.
well, I wouldn't agree that the court just went the way it did. The court heard all the evidence that was presented and considered the evidence that had been presented at 2 prior evidentiary hearings to come to its conclusion. So the court acknowledged, again, that the nation made it very clear. And at my request, the nation submitted a formal letter to make it perfectly clear that this was the nation's position. The nation, however, did not intervene and has not intervened in any of the appeals in this matter to assert that as their position. And so they have relied on the intervener to assert that position on their behalf, and the intervener did so and has litigated ferociously throughout this case, to her credit. And nevertheless, the court, after hearing all that evidence and hearing all the evidence from the department, and even hearing the evidence from her own expert witness, concluded that it was not in this child's interest to move her from her current placement to even a placement that was preferred by the nation. And I think it's significant that the only reason the nation's worker articulated for preferring intervener over the current placement was that she had the child's sibling in her care and that she would facilitate a relationship with the tribe. When she did not acknowledge that the child has another sibling who the foster parents have an established relationship with, and that they had also indicated that they were willing and actually trying to facilitate the child's relationship with the tribe.
So the child involved in this case loses out because the child that isn't in this case is being handled in a different fashion? Is that what you're saying?
I'm sorry, which child are you referring to is handled in a different situation?
Well, that's my, because they recognize that there was another child, I think is what you said. That's a third child, correct?
That's the intervener's adopted son.
So they didn't apply it in this case because they hadn't applied it in that case? I'm trying to figure out what you just said, because you said they applied it, and that got my attention. They applied what?
I'm not sure. What I was referring to is that the nation indicated that it's basis for preferring intervenor was that she had custody of this child's sibling.
Yes.
And so, and would facilitate thus the siblings being raised together. What the nation did not acknowledge was that this child has another sibling who is not in intervenor's care, and with whom,
And this is the point I wanted to hear you make.
well, and the child involved in this case had an established relationship with her older sibling. Her older sibling had essentially raised her from birth until she was almost a year old, and DCS removed her. And the foster parents already had an established relationship with the older sibling. So they had been fostering that relationship. Whereas with the newborn.
But that's not the case any longer. That
And-
relationship is ended, right?
And, yeah, I looked at that, and that's kind of fallen apart because of the needs of the older sister. And I don't think the trial court counted that. When the trial court was listing factors, I'm not sure we can say the trial court relied on that.
The trial court is the judge hearing the older sibling's case as well. So the trial court
Right.
is well aware of that child's needs and the issues that have arisen in terms of visitation with that child. I think the evidence was that the foster parents continue to be willing to foster that relationship once the older child is psychologically able to participate in those types of contacts. And I think it's significant that intervenor has acknowledged that he knew of an IGA at the time that he questioned the nation's witness, and yet claims that the department somehow was unethical in not providing the current IGA to the court.
I think he says it was unavailable on any website.
And we discussed that at the last argument, and I acknowledged that although it was available on the department's intranet, due to an oversight, it wasn't available elsewhere.
So
Now,
he's correct in his assessment.
that it wasn't available to the general public on a website. It was available upon request, and as I noted in our brief at the time, had he called me, I would have sent him a copy right away.
Is it available now
It
publicly?
is. If you go to DCS's website, there's
Is
a
that
search
in
bar.
our record or?
I don't recall. I avowed to the court at the last oral argument that I would make sure it was, and it was shortly thereafter. So it's available just by searching IGA on the department's website. I checked it just the other day, just to make sure. But they did immediately after the last oral argument. That's actually the first thing I did when I left here, is got on the phone and said, make sure this is available publicly, and it is. And it has always been available upon request. And as intervenor has acknowledged that this has the force of law, and the department is not required to provide a copy of statutes or cases to opposing counsel. So had they been interested in receiving and reading this IGA, it was available. All they had to do was request it.
It was available, it was in place, it was relevant, it was the relevant law, as you say. We just didn't follow.
As I said, it was an oversight at the time. And as soon as it was brought to our attention, we acknowledged that, yes, this is a valid placement preference under ICWA adopting the IGA, and the court needed to consider it. The court has no further questions. Thank you.
Counsel.
It's up to you.
How about if we give you 2 minutes? We need you to make it quick. You've already used your 20. Yes. You okay?
As long as she doesn't object or, okay.
How about 2 minutes, counsel?
And I will sound like an auctioneer, I will go fast. This idea that there was no knowledge of this document and its effect, I would just ask you to read the opening brief, page 50, and Dawn advised you on the trainings they've done for all personnel. All personnel. They did training. And I attached Exhibit B. You've got it. It's a transcript from the last hearing.
I think as you walked away before, you said you want to talk about the standard of review.
The standard of review is important because it is de novo review on the primary issue, and
Which is what?
which is the good cause issue.
Well,
Did they have the basis? I also think it's de novo on the issues on the change of judge and the sanctions, because it's a legal issue on those as well. Now, best interest.
How can it be de novo on good cause?
and what's the case that says that?
Well, It's because they're telling you that the interpretation of good cause is beyond what is set in the statute and the regulations.
Okay,
That's
all right, so
legal.
the statutory interpretation is de
It's-
novo, of course, or the
yes.
regulatory interpretation. But then whether the facts, whatever the standard is that we ultimately decide, we would defer to the factual findings of the trial court.
But you have to look carefully at those. I don't think you're bound by them because there's not, they said the standard is reasonable evidence. It's clear and convincing evidence. You can't get around clear and convincing evidence by saying there's extraordinary circumstance. They have to prove by clear and convincing evidence. I am using up my time, but best interests, we gave you a case on point. It says you cannot be using vague ways of getting around the regulations. That's what they've done. It's clear and convincing evidence. It's not reasonable evidence. That's their position, page 23 of their brief. There is no special needs with this child. Dr. Roll, I would ask you to read his testimony.
We're good on that.
And finally, Natasha Wright, there is no relationship between that older child and her little sister. Natasha even took her to the judge's court to try to tell her they're not allowing visits. These
Okay.
children need to have a relationship.
Thank you, counsel. We are concluded at this time. Take the matter under advisement and issue a ruling in due course.